morning, everyone. The House Judiciary Committee will come to order in lieu of a roll call. If the members, starting with Representative Williams, could just introduce themselves and go around, and if anyone is on Teams, if you could unmute and recognize when we're completed. Representative Williams.
Good morning. My name is Dan Williams. I represent the 74th District in Chester County. It's good to be here this morning, and I'm looking forward to learning some things that I need to understand. Thank you, Chair.
Hi, I'm Christine Howard from the 167th District, also in Chester County, the Malvern, Chester Springs area.
Thank you, Representative. Folks online, starting with Representative Schemmel.
Good morning, this is Paul Schemmel from Franklin County.
Representative Hanbidge.
Liz Hanbidge from the 61st. And I apologize that I'm not there. I've got a really bad cold that I don't want to give anybody.
And then we'll do Rep. Hohenstein, Sanchez, and then Schusterman.
Joe Hohenstein, House District 177 in Philadelphia.
Good afternoon, everybody. Ben Sanchez, or good morning, everybody. Ben Sanchez from Montgomery County.
Good morning, Rep. Schusterman, Chester County, 157th.
Great, thank you, everyone. Representative Rigby.
Rep. Jim Rigby, 71st District, Cambria, and Somerset counties.
And thank you filling in as chair. It's great always to see you, Representative. Together, I'm Tim Briggs, rep from Montgomery County and chair of the Judiciary Committee. Together, we're coming together to take a closer look at House Bill 2018 by our colleague, Representative Hanbidge. It is her hope and ours, I'm actually a co-prime, to streamline the child custody determination factors. Some legislation was passed recently, otherwise known as Caden's Law. I'm drawing a blank on the number. That's going to require a little bit of additional work on 2018 to, I guess, gel it with the current law. So we thought today's hearing would help us in that effort. I'm going to see if Chair Rigby wants to add any opening comments before we go to Rep. Hanbidge.
No, I'm looking forward to the testimony today. That was one of the questions I had, was there a conflict with Caden's Law, which was Senate Bill 55, and we can discuss that after the testimony. Thank you.
Thank you, Representative. Senate Bill 55. Representative Hanbidge, if you'd like to provide any opening comments before we begin the hearing, you're in order.
Thank you, Mr. Chairman. I appreciate the opportunity to bring this bill before a hearing today, and I'm grateful for the speakers that are going to join us. In 2011, the custody factors, the things that judges and courts look at in making custody determinations, were modified heavily for the first time in a couple of decades in Pennsylvania. For practitioners like me, I had practiced some family law. This was a really welcome change to give families, judges, attorneys all more information about what courts were looking at in making these decisions, and a little bit more transparency. What we did find was that some of these factors were duplicative in nature, and they were causing a lot of work for courts and then costs to families who are having to pay for attorneys or having to navigate the system on their own, and the redundancies created by some of these factors. So I'm hoping that with the help of practitioners and the help of judges, that we're able to make this system more streamlined so more cases are able to get through this process. We always forget that the people that are most affected by custody hearings are the children involved. And for kids who are waiting 9 months, 12 months, 16 months, 2 years to get a determination on some custody case, that's a large portion of the time that they're going to be spending at home with their parents. So if we're able to streamline this process, keep them safe, make sure that everything that's relevant is being looked at, but not looked at too many times, we're able to help those families and children get more relief. So I'm really grateful to our panel, and thank you so much for hosting this, to the chairs.
Thank you, Representative. We're also joined by Representative Perry Warren from Bucks County, a member of the committee. First panel we are going to hear from is Judge Daniel J. Clifford III from the Court of Common Pleas in Montgomery County. Thanks for joining us, Judge Clifford, as well as our former colleague, Judge Tara Tuhill from the Court of Common Pleas of Luzerne County. Judge Toohill, welcome back to Harrisburg and to the Judiciary Committee. We served on the committee for a number of years together. When you are ready and situated, you may begin. Judge Clifford's going for the mic. Judge Clifford.
How's that? All right. Well, thank you, Chairman Briggs, for the opportunity to appear here today before the committee to discuss House Bill 2018. By way of introduction, I am Judge Dan Clifford from the Montgomery County Court of Common Pleas. I've been active in the family court realm for 40 years this year, as first a family lawyer of a considerable practice, and now as a family court judge. I was elected in 2015. So I serve as the administrative judge on the Montgomery County Court for Family Division. Our Family Division has 7.5 judges assigned to it, so it's a fairly large division. Each judge has roughly 4,000 cases assigned to each judge. Luckily, they don't all explode at the same moment, but it's a fairly large caseload. So I am joined today by my colleague, Judge Tara Toohill from Luzerne County Court of Pleas. Judge Toohill was elected to the bench in 2021 after serving in the House of Representatives, as you noted, Chair, and that included service on this committee. So we appear today as part of the family court section of the Pennsylvania Conference of State Trial Judges. This is the conference of all the trial judges and appellate judges in Pennsylvania. There's 462 trial judges serving in our 67 counties. Most of those judges have some type of family responsibility. If they're not assigned to a division, they may be between two divisions, or in a smaller county, they might be just about doing everything, all of it. So our section meets every year twice, and we received this bill from Representative Hambidge, and we passed a resolution in support of it. The resolution is in depth. It's only 4 paragraphs, but it's part of the prepared testimony today. So I'm going to start by talking a little bit about what happened before the factors. So the factors have been in place now for about 11 or 12 years, maybe 13. Before the factors, as a family lawyer or litigant, you would go before a judge. You would have a custody trial. It could be a day, 2 days, 3 days, however long it would be. And you would probably get a 1-sentence order from that judge after that. Primary custody to mom and every other weekend for dad. And that would be it. You would have no way of knowing what that judge was thinking about when they arrived at that decision. So the factors were enacted to basically require judges to go through the enumerated factors in each case. So in every case, we need to address 15, and then there's a 16 factor we can throw in what we'd like to throw in. And that's a good thing, because now litigants, attorneys, everybody knows exactly what the judge is thinking. This is also important, by the way, because sometimes judges rotate out and a new judge comes in and takes over the case. So they can just look at that, the factors from the last go around. And what you probably know from some of the judges you may speak to in your respective counties, family court is exploding with filings. We have numerous pro ses who decide to file within a few months even. You could have a full trial and a few months later they're filing another petition. So it's a revolving door for some of those folks. So the fact that we need to take the time to address the factors is important on the one hand, but it also is somewhat cumbersome, because if you look at some of them, and that's some of the examples I put into the testimony, there's certain words that are used in a number of the factors. So for instance, the word stability is mentioned in factor 4 and factor 9. Education is mentioned in factor 4 and factor 10. Emotional needs is mentioned in factor 9 and factor 10. So you're probably asking yourself the same questions we're asking ourselves as we go through these. Is it really necessary for us to go back over the same thing we've just gone through? Now, in terms of the factors, a judge can do them on the record at the end of the hearing, or they can do them in writing. But either way, whether it's in writing or on the record before the parties, it's somewhat awkward to keep talking about the same issue over and over again. And the lawyers and the litigants have to keep facing or addressing each factor as they go through it. Often they're sitting there with the factors, and they're like, oh, well, I already talked about that. Why am I doing this again? On the other hand, there's a factor called the availability of extended family. What does that mean? Does that mean It's important that you involve your extended family in the child's life. What if the extended family doesn't get along with that parent? Is that what we're supposed to be doing, or is the extended family supposed to be available to provide childcare? No one really knows what that factor is. We've all struggled with that. And then there's a factor that we looked at, actually, that's not in the factors. So in most cases, a custody schedule will be revolving around a parent's employment responsibilities. There's no factor that talks about the parent's employment availability. So we've proposed that that be included. That's in the bill. So all we're really looking to do here is to tweak the existing factors. We're not looking to change what was just passed. I think you used a really good word, Chair, when you said gel. That's exactly what we're looking to do. We're looking to gel these other factors. Now, we've been working on these for 4 or 5 years. When I say we, I mean the Joint State Commission and the bar, and the judge group. So we've been working in collaboration on this for a good 5 years. So I think that may have even predated the Cadence legislation. So we've been working on this. Now we want to go back, or have you assist us, hopefully, work with us collaboratively to reduce the repetitiveness and include some factors that we found we should include, okay? This is not controversial. I was talking to somebody in the hallway and they mentioned, well, this doesn't seem controversial. It isn't, okay? You're not gonna see a packed hearing room on this, okay? You're not gonna see protesters in the rotunda. This is in the weeds, I like to say, of policy making, okay? The stuff that's done usually by staff in the back room in a collaborative way, but it's not, let's say, sexy, right? It's not gonna really catch a lot of people's attention because it's basically our busy work. This is what we're required to do in every custody case. And I think I put the stat in there for you. I don't have the number for every one of your counties, but in 2023, there were over 41,000 new custody cases. That does not include cases that are already in progress, the repeated modifications, doesn't include that. So it's an overwhelming number of filings in our system. And we, as judges, are drawn with many important issues. We're dealing with drug and alcohol abuse. We're dealing with domestic violence, neglect. These issues require a lot of our time. And the more time we are spending going over things that we just talked about 5 minutes ago, it just drags us down, both in the courtroom and then outside the courtroom when we're putting our factors into writing. I'd also like to point out, I think you mentioned Chair Briggs, but my colleague here served in the House, and I have to mention Act 102, which originated in the House, in this committee, when Tara was a representative. It was introduced, and it was passed in October of 2016. It's a perfect example of how this committee can work collaboratively with the judges and the legislature. That was the most significant revision to the divorce code in 30 years, okay? And it was a collaboration by all the groups. It wasn't opposed by anybody because it was one of those policy type things that are in the statutes that we live and breathe with every day, but they're not really controversial to the general public or really anybody else. The fact that you can find the entire Bar Association and all the judges on the same page is probably incredible on something. Usually people disagree about something. It's unanimous on this, in this legislation. I should also point out there's another piece of proposed legislation that the Joint State Commission just delivered to the liaisons from the Joint State, and that's to tweak some of the relocation language in the statute. It's also another issue that can be worked on collaboratively. There's just nobody that's going to oppose it, but it will make it more, what I like to say, more user-friendly for all the participants that are involved, the judges and the litigants and the lawyers. So I think that everyone's pretty much in favor of that. So now I'm going to turn this over to my colleague, Judge Toohill.
Thank you, Judge Clifford. Hello, everyone. Hello, Chairman Briggs. Thank you for welcoming us here today. It's really a great honor to be back in this room with all of you where I have worked with you before on this very committee. So it is a great honor to be welcomed back. So thank you. I want to thank all of you and the legislators on Zoom as well for taking the time to hear testimony today that impacts children in Pennsylvania and families in Pennsylvania. So this is very important information. So after leaving the legislature, I moved then from the legislative branch to the judicial branch. And I know how difficult your jobs are and how time-consuming your jobs are, where it impacts your family life, impacts time that you would have with your family, and I appreciate that so much. And I thought really leaving and going to the judiciary that maybe it would be a little bit different. But the demands of the court system don't really allow for a lot of time. So it's very hard to take time even to come here today because all the cases that would be heard today are moved to a different day where they have to be heard immediately. And family court judges are under tremendous strain. So usually in a lot of counties where there's divisions, if you are a new judge, they send you to family court first to kind of get your feet wet. And, but if you're 40 years of experience, that would have helped me greatly. So having more experience in that field would be helpful. So I'm 2.5 years in, and I still feel like every day I'm learning something new, and it's very difficult, and you're facing families that are having complete crisis and are having many difficulties, substance abuse, protection from abuse orders, mental health issues, families that are coming right out of children and youth, so they're not at the level where children and youth would need to help them, and they're getting then thrown into custody court. So it is a lot, and their family court judges do have a very high burnout as well, because it is really sad stories that are going on with families, and it can be very exhausting day to day dealing with conflict, and also families that are not going to resolve conflict, and the only way is for it to be litigated in front of a judge and have a judge make those decisions for the families. So the 16 factors, one thing I wanted to point out, so when I became a new judge, three judges that I was friendly with, they gave me a chart. So there's actually, this looks very messy, but you could use a chart, or you can use the 16 factors printed out on these multiple pages, which would take, if you give spacing for, as a judge, to write in everything you need to write in on all 16 factors, it's about 8 pages just blank, leaving a little bit of room. So in the chart, it says mother and father, but really, the families that come before us, we have a mother, a father, we'll have an aunt, and we'll have a paternal grandfather. So sometimes there's 6 folks that are all trying to grab at a child and take time with a child, and everyone is putting forward a different best interest of what the custody schedule of that child would look like. So this chart doesn't really help me because it just has mother and father in a traditional situation. Where there really are so many other family members. And then in cases where someone is trying to relocate to another state, you can have 16 factors, and then you can have another 10 relocation factors. So sometimes you're looking at 26 factors. And we have to err on the side of caution when we're doing this analysis, because anything you miss as a judge, say factor 4 is not relevant, well, then I can get appealed, and that can be sent down then from the Superior Court, where they will have me redo the entire trial if there's an error. So one of the factors, so not only is there just not only one child in these cases, there's multiple children. So in order to have a productive judicial interview, which Judge Clifford worked very hard on judicial interviews of children. They call them in cameras sometimes, where you have the child in chambers and you're able to try to get a child to be comfortable enough to disclose to you a well-reasoned preference and what their reasonings would be of what household they want to spend more time in, and maybe to disclose to you issues that are going on that mom and dad or the other parties are not going to tell you in a trial. And so that takes time. So some judges, they'll have the siblings together. I separate the siblings, and so that takes extra time. The child has to be pulled out of school. It has to be scheduled. And so that a trial that should be, everyone says, oh, it'll be just one day. It's going to be easy. It's going to be a one-day trial. Really, those are 1, 2 day, could even be 3-day trials, or you're calling them back for day 2 where the children are going to get brought in. And it's important that the siblings, that takes time as well. So we're not asking for a change in factor 7, which is the well-reasoned preference of the child based on the child's maturity and judgment. That one would still be there, but it's just important to know that on the judicial side, it does take time, and all of these items take time, and which in custody court you find that you don't have a lot of because we go by a rule. So there's a 15-day rule. After you hear the trial, you have to issue your opinion within the 15 days, a well-written opinion that could then be appealed to Superior Court. Everyone has a right to appeal. There's an absolute right to appeal our opinions and orders. And Judge Clifford touched upon this, but you go through all of these factors and you put so much time while you're in trial listening and trying to see where all of the testimony and evidence fits into the 16 factors. And then at the end of the day, the biggest decision you're making is this custody schedule, where you're maybe weren't looking at that. And that deals with mom and dad's work schedule, grandparents' work schedule, whoever the parties are, the timings of their exchanges. When they exchange, do they have to exchange at a police department because they are so high conflict that they're going to argue in front of the child in the parking lot, creating a whole other PFA issue or a criminal issue for the other areas of the law. So there's restrictions, there's supervised visits, court-appointed supervisors, professional supervisors. Sometimes you have to find out while you're in trial who would be this family member that's even willing to deal with the parties and help with exchanges. So there's a lot that goes on there, and work schedules are in flux. It's very difficult. So that's not part of the 16 factors, this conflict that's running throughout, usually, if it's not an easier case, which really few of them are at the level when you're coming to trial. And just the schedule, when people are actually available, who can actually get the child to school and deal with all of that with the schedule. So I think that's part of it, and it's not one of the factors. And then Judge Clifford mentioned this, but the custody litigation is so expensive. So we'll find that a party will then drop their lawyer at some point and say they're going to go forward self-represented, they're going to do everything on their own, which makes it difficult because even lawyers and judges reading these factors will say, oh, well, I don't understand, like sibling factor and available family, like can't that all be grouped under one factor? There's questions that come up as you're going through it in reality that you're repeating yourself, and it kind of sounds silly even that you're repeating yourself. But then once one parent does it, then their attorney on the other side is going to do it, and we're spending all this time on issues that really may not be impacting the best interest of the child, or they've already been addressed and you need to move on with the testimony. So in closing, I just want to thank you for having us and making the time to bring up this legislation. It's very important to always look at how you can better the lives of children and families in Pennsylvania because they are hurting. And so we appreciate the Judiciary Committee's attention to this today. Thank you.
Thank you very much, Judge Toohill and Judge Clifford. Anyone online have a question? Just pop your hand up. I'm having a hard time seeing the screen. Anyone in person have any questions? Chair Rigby.
Thank you. Judge Clifford, I was the one to talk to you in the hallway.
Yes.
Judge Toohill, I thank you both for your testimonies. And so one of the questions I had that you answered for me was, who is pushing for these changes? I to know if this was something being done legislatively or if it was a driving force by the judges. And you told me it was the judges that you've been working on with this for 5 years now. These are some of the changes that you felt needed to be made. And again, it's non-controversial, and I believe it's 16 down to 12, but it's really not eliminating anything. It's just house cleaning, basically, right?
Yes.
Eliminates the repetitiveness
Yes.
of the process.
I should mention, though, that this is really the origination of this was from the Joint State Commission. And I believe the chair is the liaison, and I think maybe the other chair is liaison to the Joint State Commission. And my colleague, Maria Cognetti, will be speaking to you shortly. It originated there, but primarily through some nagging, for lack of a better word, from the judges, that's, including myself, by the way, that serve on the Joint State Commission. So this is your arm of the legislature to help advise you on legislation. So that's where it officially came to your desk. And then Representative Hambridge took it under her wing. Similar to the relocation statute I just talked to you about, that landed on your desk, the liaison's desk, maybe 2 weeks ago or something like that. And we're hopeful that someone will take that on as well, because it's another instance of non-controversial tweaks. These are just tweaks to what's there now. We're not looking to eliminate them. We're just trying to tweak them a little bit to make them more user-friendly, because everyone's in favor of user-friendly things right now.
Thank you. And Judge Telhu, you had mentioned that you're seeing more clients now that are coming unrepresented, representing themselves. Is that creating any kind of a burden on the court systems? Is it prolonging some of these cases that maybe it wouldn't necessarily be if they were represented properly?
It does make it harder if you have two parties that they already cannot reach agreement and they're having conflict, weekly, daily, with regard to custody, and then they're representing themselves. It's very hard, because if they were represented by a lawyer, the lawyers would at least try to speak with each other and reach items of agreement. So at least you'd have, maybe out of 16 factors, there'd be 4 maybe that could be agreed upon. I'm not sure. And so that user-friendly, that's a good term to use that Judge Clifford is putting forward, because since the 16 factors aren't user-friendly, they're not user-friendly for judges and lawyers, it's very difficult for these moms, dads, grandparents who are trying to bring a case before a judge.
I would just add that there's been an explosion of litigation by self-represented folks. I have one case where she's filed at least 300 petitions in 2 years. Now just think about that. I've got to stop literally almost every other month to devote time to that case. And they're serial filers. They're not using any discretion. Most attorneys will use some discretion about coming back on a modification. They'll talk to their client and say, well, you know what, you were just in front of this judge 3 months ago. Why don't you wait and see how things go? And maybe in a couple months we'll go back. There's no reticence to the reticence to the self-filer. They're just going to keep filing and hammering away. They take a huge amount of time out of our schedule. And even like Montgomery County, you used to walk into a courtroom and there might be, 2 cases without attorneys. Everybody had attorneys, and it's really changed drastically. Philadelphia's been the prototype of that for years with the self-represented folks. But Montgomery County, the neighboring county, the 3rd wealthiest county in the state, we have an explosion of self-represented, and it just drags everything down.
Thank you both for your testimony. Thank you, Chairman Briggs.
I just have some comments to follow up on Chair Rigby. The Joint State Commission, what is it?
Joint State Government Commission.
State Government Commission is a very valuable resource for the committee. Chair Kaufman and I are the House Judiciary appointees to it. Senator Sanacero and Senator Baker are the Senate liaisons. And the work that is done by the task force, its practitioners, its judges, it is well thought out, deliberated product that comes to us with real need for us to take action. I've only been the majority chair. We've been in the majority for 15 months or so. This is a priority. I've spoken to both Senator Baker and Senator Sanacero about Representative Hanbridge's proposal to try to get something accomplished this year. But I think, as you mentioned, the drafting and the nitty-gritty and the staff, we're going to need your help, and the practitioners who are panel too, to come up with what you know, it took a long time to get to this proposal. I don't think we're going to have to spend 5 years, but I think we're going to have to, you know, sharpen our pencils and try to draft a good amendment to accomplish the streamlining this, but also what the legislature passed in Caden's law. I don't think it's going to be overly complicated, but we're going to need your help to get it done. And I want to thank you for testifying. Thank you for your advocacy. And you know, you mentioned the self-filers. Many times I've spoken to residents, family, constituents who are dealing with the other side. They are being represented. They're defending against these filings. And if it's every other month, there's a cost out of our friends and family that are defending themselves. So I'm not sure that that's a greater issue to how to get around that. You know, we all have a right to defend ourselves, but it gets abusive, and that is something that I think we also need to look at. The third thing I wanted to mention is we already have a taker for the relocation.
I was just going to say, it sounds like we have a sponsor for
well,
that.
well, I'm always interested, but Representative Hanbridge has been texting. She's interested to take that on as well. So we will share that with her. I think it's valuable. I mean, I don't know if we can combine it into one bill, but I do want to thank you all for your advocacy and your hard work to advance.
I'm not going to steal any thunder, but my colleague from Joint State will tell you that we did a very intensive review statewide for all 49 other states on these factors. So it took a considerable amount of research and time. It wasn't just, we sat around and came up with these ideas. So we looked at all the other states to see if we're missing something. And actually the employment schedule was from another state. I mean, I think if we had a working group with you guys, we could probably knock this out in an hour, I would wager to say. So.
Yep,
All right.
I agree, and thank you very much.
Thank you, Chair.
Thank you.
Thank you.
Thank you.
Was there anyone else? I'm sorry. I'm trying to see. Thank you.
Running out of the hot seat.
Panel 2 consists of 3 attorneys with extensive practice experience in child custody matters. First up is Attorney Maria Cognetti from the Cognetti Law Group locally. Also Attorney Hillary Mooney from Obermeyer, Redmond, Maxwell, and Hipple, and Attorney Darren Hoist from Howitt, Kissinger, and Hoist. You may begin. I'm not sure if you've talked about what order you're going to go in. I see Counsel Cognetti grabbing the mic. You may begin. Thank you.
I am the oldest by far, so they have given way to me.
I always defer to Ms. Cognetti.
And I think you're usually a little bit to the right on that panel, but you know you can just situate. I think I always see you sitting. But thank you.
I did. I was actually saying my normal seat is over there, but I haven't been here for a few years, so it is so nice to be back today. This is such a good sign for us that you all are so interested in this, and now hearing the interest in the relo bill really makes me feel good because that's one of my other babies. But good morning, Chairman Briggs and other members of the Judiciary Committee who are here today. I am Maria Cognetti. I am a Camp Hill local family law attorney. I have done nothing but family law since the day I got out of law school over 46 years ago. Actually wanted to be a tax attorney, so. The first 40 years of my career were primarily custody cases. If any of you are old enough, I sat here many years ago, and this room was filled with the fathers' rights groups. Have been involved in custody legislation for quite some time. Yes, I am that old. And I practice in about 20 of the central Pennsylvania counties, so I have a lot of exposure to judges, to courtrooms, to process. But as has been noted, I think, I am here today in my role as the chair of the custody subcommittee of the Joint State Government Commission Advisory Council on Domestic Relations Law. I have chaired that committee, I believe, from its inception, which is somewhere between 20 and 25 years. So I have been here a number of times. I'm also a past chair of the Pennsylvania Bar Association Family Law Section, and I am a past president of the American Academy of Matrimonial Lawyers. As Representative Andrews noted, the first version of these factors came out in 2011 in a bill that was drafted by this same committee. I will say the committee has changed over time, but we have some core members who have been with me for close to those 20 years. several years after the original factors came out in 2011, we started already working on redoing, refreshing, revamping the factors. I think I'm not going to repeat a lot of what Judge Clifford said because he really covered most of it. And right now, he and the other two judges that are on my custody subcommittee have absolutely been invaluable to keeping us on track and keeping us moving. But I will say, and Judge Clifford started to go there, in our search to clean up the factors, we did, and it was a subgroup of the committee, spend an awful lot of time doing a whole 5049 state review to make sure that our factors were in line, that they were covering the right things. We got some ideas on how to streamline, and that study of the other 49 states really helped guide us a lot. I will tell you from the practitioner's perspective, and the three of us can all speak to that, having the factors that we have right now that are somewhat repetitive is really difficult also from our end, because when we're preparing a witness to testify, you want to walk the witness through all of the factors, and you really want to do it in order so that you help the judge when they have to draft their opinion. But you're asking this question on factor 2, and then you kind of have to ask the same question on factor 11. And the same thing happens when you're briefing the case. I brief everything for trial. A lot of people brief after trial. But it's very difficult to do that. And again, you're talking about time spent that doesn't need to be spent. I will say, in speaking for joint state government, as I said when I first sat down, we do look at our job. One of our primary directives is to offer legislation, to help with legislation. And in this case, I am really hopeful that you will look out to us to assist in cleaning this up. We do understand that we need to get it in line with Caden's law. We've been looking at that, especially Judge Clifford and I have been looking at that for some time, and we are prepared to help you all in making the two sections of this section jibe together. We know that's very important. I do think it is a fairly easy task. So we do stand ready to do that with you folks. I believe, if I can kind of throw this in, I think we can do that with the relocation statute. That one we also took a lot of time on, and that was kind of, I'm only the chair of the subcommittee, but that one was kind of, I think, my baby, because I did a lot of relocation work, and the current relocation statute and rules don't work at all. And we won't get into that today, but I think that what you have on relocation streamlines it again, clarifies it, makes it easier for litigants, makes it easier for the attorneys doing that work. So if there's any possibility that you would like us to work with you on both sections, absolutely, my committee, and I know the judges are so ready to help with that. I will take any questions if you have anything left for questions.
Let's go to the next two lawyers, and then we can do questions at the end. I do want to, I don't know if they're still on, but we were joined online from Representative Emily Kincaid from Allegheny County, and Representative Chris Rabb from Philadelphia joined the other folks as well. So Hillary, if you want to go next.
Good morning. Thank you, Chairman Briggs and Representative Rigby. And I'm happy that Representative Warren's here from my home district. So nice to see you.
At least one person's happy that morning.
Thank you for taking the time today to hear our testimony and consider the issues that are deeply important to family law practitioners across the state. My name is Hillary Monet, and I'm currently the chair of the family law section of the Pennsylvania Bar Association. I also, for like the last probably 8 years, have served as the co-chair of the Bucks County Family Law Section Bar, and I'm a member of the American Academy of Matrimonial Lawyers, joined by Darren Holst, who's the immediate past chair of our section, who's also an Academy Fellow and also a fellow of the International Academy of Family Lawyers. We are so invested in this bill as a family law section that we took the time to have a report and recommendation drafted voted on by the council of our section, approved, and then took it to our Board of Governors, which consists of 26 members in leadership positions, and then again to the 316 voting members of the PBA House of Delegates. And I tell you this because we're basically representing the 20,000 members of the Pennsylvania Bar Association and the House of Delegates who voted to support our report and recommendation and therefore support our bill. Do so because they understand the importance. And when it was voted on at the House of Delegates meeting, it was almost unanimous. So as family law attorneys, Darren and I and Maria see this every day. We see how custody cases go through the process. And while the factors have been extremely helpful to all of us in having a roadmap to follow, like you've heard my colleagues say, the issue is when we're preparing for a trial, if we're looking at a custody case, we're starting in most counties by doing some sort of brief, as Maria said, or pre-hearing statement. And that's going to involve laying out each factor and then painstakingly going through the detail of how does what my client does support each of these factors. So doing that, when you have repetitive factors, you're trying to come up with like little details of what might change from factor 2 to factor 9, you know, and you're sort of repeating yourself. So you're going through repetitively, and you're doing that in your pre-hearing statement. And then we go into court, and to follow on what Judge Toohill and Judge Clifford said a bit earlier, while there may be 40,000 new cases each year, cases come back for modification. Children are children from when they're 1 to when they're born to when they're 18. And we see custody cases that start when these children are born. And so there may often be modifications filed. So if a judge and counsel with litigants has to go through all of these factors and then 2 years later, there's a modification, you're going through the 5 factors again, because each time we bring a case before the court, the judges are required to go through each of those factors. So it's not even a one and done. So we're looking at, if we streamline, it's going to be easier for us to prepare our litigants for court. We're going to cut down on costs by cutting down on what needs to be in our pre-hearing statements and our briefs. We're going to cut down on the time we have to prepare our clients, and I think we're going to cut down too on the time that we're in court, because then you put your client on the stand, you put the other party on the stand, and I work with a chart like Judge Toohill mentioned, making sure I'm checking off every factor with my client as I go along, and then when the other party is testifying, doing the same thing. And it may not just be 2 parents, it may be 2 parents and 2 sets of grandparents. So then you're doing it for everybody as you go through that. And in many counties across the Commonwealth, we are not having, you're not necessarily having a 1-day custody trial. It could be a 3-day custody trial. And speaking Bucks County in particular, you go in to try your custody case, the majority of your time, you're on a list with 5 other cases. So you may not be starting your case that day. If you do start, you're not finishing, and your next day is not the next day, it's probably 3 months down the road. And then you need a 3rd day and a 4th day, and you're even further down the road. So by consolidating and streamlining some of these factors, it will allow us to better prepare our clients and really lead to a lot more judicial economy in the courtroom. As you heard the judges say, they have to do the same thing when they have ultimately rendered their decision. So by streamlining and working through that, I think we will be much more efficient and much more cost-effective for our families. And as my colleague said, the Bar Association is very lucky to have worked with the General Assembly on bills before. I'll point to Act 12, the PA Family Law Arbitration Act, which we're so happy to have seen passed very recently. And we're willing, able, and really hopeful that we can do that again. I'm going to turn to Darren if you want to talk a little bit about the harmonization with the kids.
Good. Thank you, Chairman Briggs, Representative Rigby, and all members of the committee for having us here today. I welcome the ability to provide some input on a very important issue, children. I echo the testimony of my fellow panelists. I'm not going to repeat what they have said, but we are looking out for the best interests of the children. That's the poll star. And if we're able to streamline the process, make it easier, make it more user-friendly, more expedient, that serves the best interest of the children. That's our focus. So we welcome the changes to this bill. As has been stated, it is not a major alteration of the bill. It is a refinement of the factors. And when the factors were implemented in 2011, it was a welcome change by practitioners, a welcome codification of the various patchwork of cases that we had out there interpreting the custody statute. So it is a roadmap. And as with the practice of law, we are always seeking to evolve, seeking to get better. So refining the factors, that is a logical step at this point in time to make them more user-friendly, make them easier to comprehend, make it easier for the judges to render decisions. So we do not see this as a major change of the factors. This is not a controversial change to the factors. As to how it implements and affects Caden's law, again, it's very clear that this bill does not neuter the effectiveness of Caden's law. It is a complement. There is a need to harmonize the language, but as has been stated, that's a relatively easy fix. And we are happy to work with the House and the legislature to implement that harmonization. So again, I have been practicing nothing but family law for the past 24 years. As Maria, I too also wanted to be a tax attorney coming out of law school, but I'm happy that my path took me down the path of family law, because we get to help families day in and day out. And so we welcome, as the Pennsylvania Bar Association and as a practicing member, I welcome changes to the statutes that make it easier for us to practice the law, easier for the litigants to get through the law, easier for the judges to effectuate the law. And that's what this bill does. And so we are on board for that. Thank you.
I just want to say I never wanted to be a tax attorney, just in case anybody had any questions.
I'm sitting here trying to figure out the connection between tax.
Yeah, I never wanted to be an attorney. Maybe you guys. I always wanted to be the chair of the Judiciary Committee. That's why I went to law school. Who would have known? Any members online have a question? We are joined by Representative Schusterman, who worked with Representative Klunk on the passage of and the creation of the Family Law Arbitration Act. The PA Bar was very helpful with that, and we were excited to get that done this session. Anyone online? Anyone here? Oh, I'm sorry. Representative Schusterman.
Yes, I wanted to go back to, sorry if I'm echoing, I'm hearing an echo, but
We can hear you fine.
when people self-represent, but then they end up filing 100, 200, this issue interests me from 2 points. One, people should be able to represent themselves, but it seems like there should be boundaries so they're not clogging up the judge's schedule even before certain cases come to light. So I don't want to do a deep dive into that issue, but do you have some kind of overarching ideas of what could be put in place without discouraging people from possibly self-representing?
I think we're going to have a little discussion on this. Judge Clifford is joining the panel. Judge Toole, if you can come up if you want to join. But Judge Clifford,
Yes.
and then.
Thank you, Representative, for raising that issue, and I think you've hit the nail right on the head. So in a support matter, child support, in order to modify a child support order, you have to demonstrate a substantial material change that existed from the prior order. In the custody modification, you do not have to indicate anything. You can just file petition modification. You do not need a basis to change the order. And that may have worked for 25 or 30 years, but with the explosion of self-represented folks, I would implore you to think about a change to the modification in a custody case. It doesn't have to be the same exact language that's used for child support. It doesn't necessarily have to be substantial material, but it should be something. They keep coming back over and over again, and nothing. I had a case yesterday. I asked the litigant over and over again, what has changed from the order I entered 6 months ago with a hearing, with findings of fact? What has changed? Nothing had changed, nothing. So if you could tweak that particular rule, it hasn't come out of joint state yet, but I'm thinking we'll be discussing it. That would help significantly with the explosion of self-represented folks to have a reason to modify the order. There was a case about this in 1989, I think it goes back to. It's one of the few case names I can remember because they changed to the alphabet soup at some point with the initials. But there was a case coming out of Allegheny County in the late 80s, which was overturned, where the judge required them to demonstrate some change from the last order, but it was overturned. That was 30-some years ago when almost everybody walked in a courtroom with a lawyer because they were all afraid to go in a courtroom. People watch TV now, they're not afraid to come in a courtroom. They can see it's a do-it-yourself society, and they do it themselves in the courtroom too. So,
Thank you, Judge.
Thank you.
Attorney Cognetti.
I would echo what Judge Clifford said. We did look at this quite some time ago. It was probably around the same time as the support rules changed. And I think that with facts like that and statistics like that, it's now ripe to look at it again. We do know, as Judge Clifford said, we can't use the same standard where it has to be a drastic change or a serious change. But at least if we put in that there has to be some change, that should help alleviate at least a good part of the issue that the court is seeing. We also see it as practitioners, though, because when we've got as I think someone talked about, when we've got the paying client who has to respond to this all the time, and the custody procedure basically by rule in every county is no less than 3 steps. And you have to have your attorney. If you're going to have an attorney, you're going to have an attorney for all 3 steps. And when you are defending something that is bogus, and you were just in court 2 months ago, 3 months ago, I will say, and I've been waiting for it to come to me, and it did, many, many years ago, Judge Kleinfelter, who I believe was probably PJ in Dauphin County back then, he actually had one of those cases that came back and back and back, and at one point he finally ruled, I'm not hearing this, you've been here too much, basically, and the Superior Court overturned him. So we really do, and the courts do need some assistance in that area, and we welcome the opportunity to help everyone come up with what that could be.
And we recognize it is a delicate balance, the right of a litigant to assert their rights, but right now, under the law, you can file if you can assert that it's in the best interest to change, but the best interest standard is so amorphous. It means different things to different people. There needs to be something more concrete, like Maria has said, like the judge has said, some type of change that warrants a review as to why it's in the best interest of the child to change the order at this point in time. And that's something we lack at this point in time.
I think it would help this committee if the Joint State Government Commission could dig into this a little bit more and as you've done, make a recommendation with some language to, the legislative process is more successful when it's, I think, working in collaboration with groups like that to make it bipartisan, that the practitioners are seeing this as an increased problem. We could introduce a bill on our own, but having your backing is valuable.
Happy to do that, sir. Thank you.
Thank you. Any other comments or questions? So I think I'm going to take the practitioners and the judges up on a work group. Judge Clifford said under an hour we could get this done. If that happens, it will have been faster than it took us to get the air conditioning on. Department of General Services was a little slow on that, so I do apologize. But I heard it go on a couple minutes ago. So I think we should, do a Teams with Representative Hanbidge. I'm going to designate Council Claudius, Executive Director Claudius, and I, and Chairman Rigby's side, to try to just to put pen to paper and come up with an amendment. I'm not going to entertain that today, but I do thank you for your offer to participate in that. Let's try to do that in the next week or so. If people's schedules can get, I'm gonna bug Damien afterwards and Anna from the bar to help us follow up. But I do want to thank all the testifiers to offer, coming to Harrisburg, providing your time and expertise on a really important subject that I think is time to be addressed. And If we do it right, it should be something that the Senate will go with us on. So I see no other comments. Any closing? Representative Rigby.
I do have one question, if I could. Attorney Cognetti, 32 years ago, I went after custody of my 2-year-old daughter and was told by my then attorney that it's Cambria County and a male will never gain custody of a female in a custody battle. Needless to say, I fired my attorney and I did get full custody of my daughter. And I'm just wondering today, do we see in custody matters, are the courts having a tendency to lean towards the mothers more than the fathers? Or back then, I understand, 30 years ago, they told me it just doesn't happen, at least not in Cambria County. Don't waste your money. And I did waste my money. I didn't waste it. I got my daughter, but I'm just curious, does that seem to be the mindset, or was that the mindset that mothers are the better custodial parent?
So I'm going to speak just from my practice, which is probably somewhat unique, and why I ended up getting and doing so much family law work was because I got known for representing dads who no one else wanted to represent, because based on the way the courts were back then, it was much harder to try a dad case. But if you tried a dad case and you worked hard, you got custody for the dad. So I've been very fortunate that I did well in my dad cases, and that snowballs, and probably 75% of my clients over those 40 years were men. I think the courts are, I'm not even going to say they're reticent anymore. I think it is all in how you present it. And I just think, and not for these folks, because you've got, some of the top family law attorneys in the state sitting here, but more attorneys need to feel that they can win when they walk in. I see so many young people, and some of them have at some points worked for all of us, and they go in and they have the dad, and they go in with the mindset that they're going to settle because they don't want to try the case. So I feel bad for your experience. I'm glad you had the sense to move on, but I think it's more, or at least an equal lawyering issue as a judge issue. I think we now have judges like Judge Clifford, like Judge Toohill, like the judges that sit on my committee, who absolutely are gender blind in a custody case. I don't get into the really, really far off counties, although I do get to some of them, but I can't speak to those. But, the 20 counties I practice in, I have no issue bringing a dad in. Now, you want to make your reputation, you bring a good dad in, you don't bring a dad in who really should be thankfully has alternate weekends, and you want to ask for primary custody. But I think the system, the problem is not necessarily with the courts. I think we have to change the minds of young lawyers. It's harder work. It really is harder work representing a dad. There are so many more things.
But he said chalk it up to experience. You don't chalk a child up to experience. And that's what I was told.
I do also really think that the custody factors being in place have helped us in that regard, because I do find that I've been practicing a little less time than Maria has, but I have been doing family law for the last almost 30 years in my entire career, and I'm passionate about it. And I do see that the factors really force both attorneys, litigants, and judges to look at, what are we trying to do here, as opposed to just, it's a mom, it's a dad. And so I do find us to be I find courts and attorneys to be definitely more gender blind. Now, I don't think of that so much as an issue when I walk into court now with my client. I look at it more as, does my parent that I'm representing have the best interests of the child, and how do we, I go through the factors with each of them, and I'm very honest with my clients. And I just had a case with a dad that I represented, and it was one that we came back to court, and I knew he was the best thing for those kids, and I don't think the judge saw it any differently. So I do think the factors have helped a lot in that regard.
Thank you. Thank
And
you. all.
I would agree. I practice in the same counties probably that Maria does. Been doing it for 24 years. There certainly has been a shift over the last 25, 30 years. Back, unfortunately, when you had to deal with this matter, that was more of a mindset that if it was the mom would get custody. But fortunately, I've seen more enlightened judges, like Hillary said, who are now gender blind, looking at the factors. The factors have been, like I said, a godsend to helping us navigate the field. But at this point in time, I do not see the biases or towards moms or anything like that. If you have good facts, you have a good client who's a father, you have to put in the work, but you have to put the work in no matter who you represent if you're seeking to have them get custody. And the courts are certainly receptive to considering and awarding custody. Over my career, I've certainly been fortunate enough to represent several fathers who have gotten primary custody, not because of any fancy lawyering on the part of me, but because they were a good parent. They had the child's best interest at heart. The court saw that.
Can I just say something to that point?
Of course, Judge.
Sorry, I can't resist. So you're absolutely right. I represented you 35 years ago. I had a lot of clients just like you, and dads did not have an advantage. I can remember going, and this is in the 90s, I don't know when your case took place. I can still remember a male judge saying to me, well, why in the world would a man want 50-50 custody of their kids? And you had to realize who you're going before. We have a phrase in law, know the judge. Most judges at that time period were older men who had never done anything for child care. Their wives stayed home. They didn't work. So the dynamic started changing around that time period where both parents needed to work. And so there was shared responsibility for child rearing because it had to be, because both parents were working. And that's why that factors for you on availability, because the availability of the parent, I think, drives the custody schedule more than anything, if there's no abuse or something like that involved. The availability of the parent is the most important thing. Are you going to be around with your child, or are you going to have child care when the other parent's available? So this is why, and I know this touches on another proposed legislation, this is why we have spoken out not in favor of presumptions in custody cases. We, as judges, we don't want presumptions. And you're a perfect example of why a presumption back then was harmful for you and your family. But again, I think it's changed completely from the judge standpoint. You have younger judges and their spouses work. Everybody works. So somebody has to be helping out, and sharing of responsibilities is far more common. What's difficult for us is to decide or sift out, well, who did what? Because they're in the house and each of them are saying they did more than the other in many cases. But for most of us, we're looking forward more than backwards when it comes to that going forward, because they're not going to be in the same house. So. But thank you for hanging in there. I had a lot of guys like you. So
Thank you, Judge. Thank you.
All right.
Thank you, attorneys. We appreciate your testimonies today and look forward to moving forward on this bill. Thank you.
Thank you, Representative Rigby. I do see Representative Hanbidge. I think this will be closing comments. Representative Hanbidge.
It's actually in response, sorry, my cold is getting to me. It's actually in response to Representative Rigby's comment as well. The majority of the case, I'm a child who was given, my father got primary legal and physical custody of me in a county where it was unheard of. And as I litigated family law cases, the majority of my clients were fathers. I also think this is a good conversation to have about encouraging the Bar Association within itself to make sure that there's anti-bias training. In all things, we don't want biases to creep in and affect litigants. And that there's always an opportunity to make sure everyone is being fair and fairly treated. So I appreciate your comments on this.
Thank you, Representative. Representative Schuster, I mean, I see your hands up, but I think it's still up from your previous comment. Do you have anything in addition?
No, thank you.
Okay,
I put it down.
Thank you, Melissa. Seeing no additional comments, I want to thank you all for testifying and always working so well with me and my staff and the members of the committee. Thank you very much. Meeting is adjourned.
Thank you.